day and welcome to today's Conversation podcast. Today we are featuring a fairly young gentleman, but a professional, Elijah Simbai. He's a vice chairperson of the Busoli Royal Establishment and is the legal advisor, one of the legal advisors. He's been holding that position since 2018. He's also held a professional job. He was enlisted in the Zambia Airforelce in 2009. He was attested in 2010, and he was a special operation airman. In 2019, having completed his law degree from the Zambia Open University, he was transferred to the Special Forces Unit from Kabwe and into the legal department in Lusaka. His troubles started then. Elijah, welcome to today's Conversation podcast.
Thank you very much, Ambassador, and I'm grateful that you have hosted me.
You've been in the news recently, and that's why we took interest in you in matters relating to the law, relating to Busoli traditional affairs, and your battles with NAPSA, with Zambia Airforelce, and just with this huge piece of land that sits in an area where there are people living in that area. But first, just briefly tell us who you are.
Thank you so much. My name is Elijah Simbai. I serve currently, like you have mentioned in the intro, as the Vice Chairperson for the Busoli Re-Establishment Lands Committee. Actually, and I have also served as advisor in that regard for legal matters on land. And I served the Air Force for a total of 12 years. The last two really would not be included because technically I'm out of the service. Although the matter is still a subject of litigation, there are judicial review proceedings that are pending. We are awaiting final determination. In fact, we are at judgment stage. So subtracting the last two very, very troubled years, I served for 12 years, 9 of which I was in the Special Ops Unit, that is 19th Squadron in Kabwe. And the last 3, I served as a legal officer for Zambia Airforelce Twin Palm Air Base, where I was advisor to the station commander there and in command at large on legal matters. And like you indicated, my troubles started there because in 2018,
let's go straight to the issues that brought you trouble. Your association with the Busoli traditional authorities, and I think because of your competencies, you were to a committee of that, the Lands Committee of the Royal Establishment. Let's begin there. What are
the issues border mainly on land. The biggest issue that the Royal Establishment has faced has been land.
First, before we go any further, define the Busoli traditional, the Royal Establishment. Who does it encompass? Who's the leader? What expanse of land are we talking about?
And a very good question and a necessary question, because actually members of the public would need to be properly informed on the issue. The Busoli Royal Establishment, in this regard, we speak specifically to the Nkomesha chiefdom. There are about 6 Soli chiefs in Lusaka province, among whom would be Senior Chief Nkomesha herself, Chief Bunda, Chief Shikabeta, Chief Mpasha, and others. But we have one senior chief in the province, that is Senior Chief Nkomesha Mukamambo II, who recently was awarded an honorary doctorate in leadership.
Congratulations to her.
Indeed, thank you on her behalf. And her realm particularly extends over 5 districts. That is the Kafiwe district, Chilanga district, Chongwe district itself, where her citadel is, the greater Lusaka district, and a portion of Shibuyunji district, which of course formerly was Mwamba district. So these 5 districts these 5 districts are covered by the Busoli Royal Establishment. So my role as Vice Chairperson for the Lands Committee is that I oversaw all land matters in these districts.
And there has been extensive encroachment
Indeed,
on the land.
Extremely so.
Because, first of all, Lusaka is seated in your area, so most of it has been alienated to state land. Secondly, is that Lusaka is, as a city, has a huge population of looking for land, and they're beseeching, I think, the royal establishment for land for people to settle.
Yeah, true. In fact, Lusaka is, you wouldn't really say it is solely land because it's a metropolis now. Everyone is in Lusaka. It's the seat of government, it's the seat of commerce. So there has been a real scramble for land. And the challenge has been that the alienation of this land has not been very, very smooth. To some extent, we could say there hasn't been proper liaison between the state authorities as well as the traditional authorities. In certain instances, and those instances are in the majority of the troubles that I've had to face, we have had land that is claimed contemporaneously by the state as well as the traditional authority. We have land that is on title, that is a state land, but then we have gazetted village registers issued by the government over the same piece of land. So there
Where there are villages, but titles have been issued.
Yes, there are titles, and then also there's a village register. There is a village headman in this committee and subjects. The ones who are claiming that land on the basis of it being state land will produce their title. And our people, we will rely on the village headman and the fact that their names have been entered in the register as subjects. And in most cases, those matters have had to go to litigation. The reason being, traditionally, state land has been deemed to be a superior version of title ownership or ownership to land. In fact, there is a mantra of sorts among legal practitioners that a certificate of title is conclusive proof of ownership to land. However, very few lawyers, and I say this because having been in court over this particular subject, I have had enough exposure to these matters and sufficient experience. I've been forced to research, read into these things extensively. Very few practitioners realize that the 2016 Constitution, and firstly, of course, politicians bicker about a lot of things about, the 2016 Constitution. Those, of course, who are on the other side, especially those who were in the opposition then, they just rubbished it all and dismissed it. But it has its own loopholes and lacunas. It's a very common nature of every piece of legislation. But it is also a good document because it did contain some very, very progressive provisions. Very progressive provisions. One such is
in relation to this matter, which provision could you cite?
Article 253 and 254, for example. Whereas previously land ownership proper was by way of a certificate of title, the 2016 Constitution in that particular provision says land shall be delineated into state land, customary land, and other tenures as prescribed. So in 2016, customary land is also constitutionally recognized as a legitimate and valid land ownership. So much that it is no longer a question of who owns, who has title, then that's the owner. The Constitution also pays due regard to people who claim ownership to land under customary law. And much of these matters I have handled, a majority of which have been won, it has been on that basis that it's a constitutional protection. It's a constitutionally protected right now. The other, of course, is 254, which states that river frontages, lake shores, islands, culturally sensitive places and ecologically sensitive areas cannot be bought, cannot be sold, cannot be leased, and cannot be fenced off. Now, that's a very good provision of the law. The wisdom of that law, in my view, was to protect communal enjoyment to these areas so that a person cannot just cut off a river.
Of river frontages, lakeside, and swamps and others is also in the Constitution.
Yes, indeed, it's a constitutional provision now.
The same Article 253 and
254, yes, of the Constitution. So of course, to those who may say it's a bad law, and majority of those who say it's a piece of trash, I think are people who have not really taken time to interrogate that document. And
no,
I don't dismiss.
A renowned constitutional lawyer, John Sangwa, is strongly against the amendment of this current constitution. He says it has to be tested, it has to be lived. He thinks that it's only when we allow it to breathe will we know what's wrong with it and what's good with it, but to just trash it in one line. So John Sangwa agrees with your thought. And
I followed John Sangwa. He's, I think, a regular guest here. I have followed your interactions with him on this podium. There are many people also, of course, who may misunderstand him and have misunderstood him, his positions, both, of course, prior to 2021 and post-21. I mean, he has introduced a lot of litigation on constitutional matters in our various courts, some of which, if not most, actually he has lost. And people then will say, well, he's an incompetent lawyer, he has lost many of those cases. But the very cases that he has lost in the Constitutional Court, for example, they have sparked conversations that have ultimately led to the refinement of the law and even giving us some of the protections, some of which are now in the Constitution. They were introduced, they generated out of some of the matters he has brought to the Constitutional Court. And I agree also with his position that we should not condemn ourselves to a position where every government that comes into power, the first thing, it appears the first agenda item is to change the Constitution. Then we are not going to have stability. We take pride in the American constitutional framework and machinery. But the American Constitution, which has lasted, of course, more than 2 centuries, but has only been amended about 26 times, it has had that longevity because its peoples allowed it to be a document of pride, one that will give some sort of stability to the state. But even if we can say everyone who comes into power, the first agenda item must be to change the law, to entrench themselves, protect personal interest, then we'll be continually a republic off balance, because we don't know what the next government will say they want to introduce, what they want to get rid of. And especially that some of these amendments are very selfish and individualistic in that maybe they're even targeting certain interests or certain persons. I think that's bad for national administration. I agree with him.
So Elijah, let's get back to the issues that have seen you out of the Air Force, because I think as an airman, they wanted you not to engage yourself in these extracurricular activities, but you have a right to belong and you have a right to participate actively where you belong, the Busoli rail establishment. And you felt that you needed to protect some people. Speak to us about that matter that has sent you to litigation, made you lose your job, and taken all these risks.
Thank you very much, Ambassador. The genesis of this whole drama, I think, finds itself in the previous administration. We awoke one day to very disheartening news to the effect that the Zambia National Service had deployed into an area, a part of Cholwe Village, in the dead of night, beat up the settlers there, burnt some houses.
Where is Cholwe Village?
Cholwe Village is by the source of the Chalimbana River. A part of it covers the famous NAPSA land, Farm B15, sub B15 or Farm 3 to 8.
So the Zambia National Service, what period was this?
Around 2020.
So they descended on a village?
Yeah, and assaulted villagers. And this is in the night, burnt some houses and beat up people. People were assaulted. I still up now keep some of those medical reports, x-rays of women, limbs broken. So when the matter reached the royal establishment, in a nutshell, of course, there was a bit of some back and forth, but ultimately the decision by Her Royal Highness was, let's find a way of protecting our people. But when we had started the conversation, would learn later on that ZNS was contracted by the national NAPSA, National Pension Scheme Authority, to be contractor in that area to build roads and bridges. So when the issue was followed up further, NAPSA produced some documents to the effect that they bought the land, they own it, it's on title. They bought it from Minwood Properties, and they had actually engaged the people, and they had given some compensation.
There was a debate under, I think, President Rupiah Banda, when it became public. I think newspapers of the day then in 2009, 2010, carried the story that a private entity, in this case Minwood, had sold that land to NAPSA that wanted to do, I think, a housing or a mixed-use project. But the issue at the time, I think, was the amount. I can't remember how much dollars that was.
Yeah, I would learn later on it was actually about $4 billion. Now,
no, not $4 billion.
$4 million, because if we are to convert, the figures that are on record now is about 75 billion kwacha. My understanding is that that's a unrebased figure. So if we were to rebase it,
with the benefit of internet, while you're talking, let me just Google
look
so that I get the correct facts. But please continue to say the background about the figures.
So, of course, the figures are subject to confirmation. The Minwood sold the property to NAPSA, but then later on when NAPSA decided that they wanted now to exploit their land, they purportedly engaged the people who had settled there. And people were given what they termed compensation.
So did NAPSA get it from the royal establishment? I mean, did Minwood get it from the royal establishment? Who converted it from state land to...
From
traditional customary land to state land? Or did Minwood find it already converted? What background do you have there?
The claim by Minwood, and that is as NAPSA presented the issue in court, the claim is that Minwood had the land on title, and the title goes way back. Now, of course, that itself is a contentious issue, but just as much as I would mention, since the matter is itself also a subject of litigation.
The land was paid for, it's 1,500 hectares, it was $50 million. I think that's what NAPSA paid for it.
Does it say 1,000?
1,500 acres of land, yes.
Or acres, okay, acres could be because it's
Is it acres or hectares? Here it says acres of land.
The hectareage that is in contention now is actually 607. It would make sense if that is an acreage quantity.
Okay.
So because 600 hectares could be, that
1,500
in acres. So it's the same piece of land. Now, because these documents here, they bear the figures that are in the actual assignment, because these are documents from lands. Now, we don't know whether what the tabloids report, the extent of the accuracy of what the tabloids of the Times reported compared to what the records are.
On the figure, what is the figure there?
The figure that is at land, the assignment that was filed at lands bears 75 billion kwacha. Now that is 75 and 9 zeros at the end. But it could be that is an unrebased figure, which would be in the rebased.
So another report is attributing the value of the land to 15 million. Remember the other one said 50 million. Yeah. This one is saying 15 million dollars. It also mentions the 1,500 acres of land. So I think it's a high value property.
Extremely high value.
So on this high value property transacted between Minwood and NAPSA, they are your subjects on that land.
Yes.
What is your contention?
Our contention is that the people on ground were not engaged, so that perhaps a way could be chartered forward that would be mutually beneficial. And by engaging the people on ground, the extension would be that there would be need to engage the royal establishment, because they do not stand alone, since they claim their right to the land on basis of their customary heritage. So it means that the royal establishment also should have been involved. But they are saying they engaged the people and that they compensated the people. The people on ground says there was no such engagement. We were not compensated. That's why we refused to leave. But NAPSA, of course, they produced some documents where the people signed. Other people cannot read or write, but then they have their initials on those so-called compensation contract. But when we looked at the
compensation contract, how much was paid?
Some were paid 3,000 kwacha. I could see figures like 3,000 kwacha, 5,000 kwacha, 2,000 kwacha. Which is, of course,
many of the people express ignorance about those payments.
In fact, majority of those, according to NAPSA's records, about nearly 30 people were compensated. 22 households.
How many households are on that village?
89 by my records. 89 households.
And that could be in excess of 500 or so people.
Yes.
Because the households may have 5, 10 people, depending on the households.
Exactly.
Okay. So NAPSA and ZNS in their treatment treated that village as illegal settlers.
Illegal settlers. And I do think that some of the things that were presented to us by the National Pension Scheme Authority were an afterthought that was intended to cover a series of bad decisions leading up to, the incident of the assault of the people and subsequent occurrences. But I was going to say,
how long has that village been there? Is it one of the new villages?
No, not. The people there have settled the land since the 80s. Okay. So we're talking about in excess of 30 years that people have lived there. But I was going to say that when we looked at those so-called compensation agreements, the people that were there, only about 4 names that are on those compensation agreements are the people that I know who are settlers there. Majority, even the people who are settled there, they say we don't even know these people. We don't know those names. So what NAPSA seems to have done was they made an announcement that on such and such a date we are going to hold a meeting. The people who are settled there, who live in the area, must come so that we discuss the issue. And there were people who trooped there from Tendere, people from all sorts of places. They just went there. And when you appeared there, they just asked for NRC and your name, and then they said, on such and such, they come and sign for such money. So majority of the people who went there,
who benefited from the
they are not settlers. That's the first thing. But then some of those, because there are 2 or 3 that
according to you, was the compensation adequate?
No, it wasn't. I mean, Ambassador, it would be, right now, if you are to say you buy property yourself for let's say 500,000 kwacha, and there's someone there on that property whom you need to get rid of, to eject, And you are saying you can compensate them for their being on the land, for the fact that they've been on the land, and then you're saying, I'll give you 10,000 kwacha. It does not. The World Bank guidelines on resettlement of indigent people and people similarly circumstanced as our people there is that the value of the compensation must be equal or closely as much to the value of the current possession. So if the land I occupy is 100,000 kwacha worth, you must give me land in replacement of this one at the same value. Alternatively, give me its market value so that I can go to my place of choice but be able to buy the same land, so that the essence of compensation is to ensure that the standard of life for the people you are compensating does not drastically or markedly change from what they were to what they... Because these people are being compensated because they were settlers there. They are not squatters. The law in this country on squatters is clear, and there is vast precedence from our courts. That a squatter, someone who builds on someone's land to which they have no right of claim, do so at their peril. So they are not entitled to compensation. They are trespassers. No? But those were settlers. If you are to resettle them, let it then be, as the word suggests, let them be resettled. And the effect of resettling people is that their standard of life in their next life does not differ or drop significantly from what they currently were.
So your people are not squatters you hold?
No, we maintain that they were not squatters, they are settlers. They were settlers.
And there's a big difference between the
two. They had been on that land long before NAPSA's claim to the land. NAPSA's claim to the land begins in 2015, 2013. 2013, that's when, according to the records at lands, title changed from Minwood to NAPSA, although the negotiations might have begun as far back as 2011, I thought, but now I'm learning now that actually they extend even as far back as 2009. But the execution of the transaction was in 2013. That's when the assignment was filed, was lodged at Ministry of Lands. But even as of 2013, those people had been there for decades already. It had been their home, their heritage. As a matter of fact, we had been fighting because from 2020, when the matter began, I have buried 7 heads of households in the area. And the first 2, we buried them in the traditional burial site, which is still in the land.
So there is even a burial site?
There is even a graveyard, which has existed for decades in the area. And when they were putting one of the roads, they had actually graded through the graveyard. We had to protest. We had to protest that we know that you have such a contemptuous regard of the people. The poor people are there, but at least have regard for their dead. This is a culturally sensitive issue. We have our unqualified sentiments towards the dead, and to see the bones of their loved, lost ones strewn on the roads like that, it's inhuman. So, of course, we had an apology from NAPSA, and they discontinued. Yes, so the road was slightly diverted away from the graveyard. I buried the first 2 in the area, but the first 3, I think, but the last 4, it's been very problematic. We have had to be up in arms against NAPSA because they would bring the police.
NAPSA no longer allows you to bury.
To bury in there, no longer allows us to bury. Now, they say, you cannot bury anymore because this is our property. And we say, but it was, this land has been on your title even as of 3, 4, 5 weeks ago when we were burying it was what has changed. Now, they say, now we have an injunction. But then, the same article 254, like I mentioned, graveyards, culturally sensitive areas, river frontages, lake shores, islands, they can't be personalized because these are communal areas that must be accessed by all members of the party. You can't personalize a graveyard. It belongs to the community. It's for all of us to bury our dead, and from time to time to also visit the resting places of our dead to conduct our cultural rites there.
Now, Elijah, this must have brought you a lot of trouble.
It did.
Well, of course, the royal establishment is very big and well respected, but you're a public official working for the Zambia Air Force. Did the Zambia Air Force learn about your extra activities, fighting NAPSA, suing NAPSA, and what was their reaction?
They did, and you see, the way you're putting it, for example, me suing NAPSA, my commanders did not take that very kindly. And I don't think they have forgiven me. And I dare even could say, I doubt if they ever will forgive me. But the basis of their hatred, and it is very heavy and thick hatred against me, the basis of their hatred is rooted in misinformation. In the first place, I am not the aggressor in this issue. I did not go to the NAPSA offices to start making noise about the land. NAPSA sued. In the NAPSA matter, I am the first defendant. So we are merely on the defense, protecting ourselves. In the first place, we are victims. But because prior to NAPSA engaging in court, I had said to the NAPSA lawyers, the land in contention is 607 hectares, where the people are settled, and most of them were just by the Chalimbana River. So clearly they were following the communal land and together with the waters of the Chalimbana River because of the gardens. And the complete stretch from where the river enters into the purported NAPSA land to where the river exits the land, that stretch where they settled covered about 64 hectares. So I had said, we could have a very easy settlement to this, cut off the 54 hectares
and leave it to the community.
Develop the 540 hectares. It wouldn't be such a huge loss. Firstly, my point was it wouldn't be such a huge loss. Secondly, I said the fact that river frontages cannot be owned, and ZEMA guided, there is a decision letter from ZEMA that was written to NAPSA, where ZEMA stated that they are supposed to leave a buffer of about 60 meters from the river inland. So if you were to count 60 meters from the river inland, and then you were to calculate the stretch from where the river enters the land to where the river leaves the land, the 60-meter stretch might actually be about 50 hectares already. So the only part of your land proper that you may have to part with, maybe 10 hectares or so, which shouldn't be a huge loss because you are still by law required that you leave this land off. It is still public land anyway. It must be open to communal consumption. But lawyers being lawyers, they were speaking big. We want every square inch of that land. We're not leaving to anyone. Upon which I said, well, we will be forced to defend the land as a royal establishment, unfortunately. We'll be forced to file a defense if you sue. They say you can't defend the indefensible. No one can. There is no defense that arises in this matter. Yeah, because they treated you as squatters. Yes, squatters, and probably we were ignorant, knew nothing. I think the moment, the time I met the lawyers, I think I was in some red overalls or something. So I was just like one of the locals. In any case, I have a small garden also in the same area. So the lawyers refused, and shortly after, they sued. So the people informed us that we've been sued as defendants. So I was joined to the proceedings as first defendant, and I filed the defense. Now, when I filed the defense, there were a number of contentious issues that we raised. The court then said this matter cannot be determined summarily because they just want, by summary proceedings and order of eviction. It says we cannot determine this matter summarily. It must go to a full trial because they are raising valid and genuine defenses, which they must be heard on that defense that they are raising. So the defense was raised, and it went to a full trial. But then they had said, we need this matter. Management says within 3 weeks this matter must be done, and within 3 weeks, once the order, you must be out of here. I had said, I don't think this matter can be terminated within 3 weeks. You are looking at 3 months or more. It can't go that far. Lawyers talking big. But it was 3 weeks, then 3 months, then, it went 2 years, more than 2 years. But when we filed the defense, it appeared that perhaps NAPSA realized that the fight is going to be tougher than we expected. And we must find ways of maybe circumnavigating the tough fight. If there is a way, we can walk around it. Let's explore those measures. Now, that's why, of course, ZNS was deployed as an intimidation force of sorts, and in typical military style, deployed in the night, beat up the people. So when I was informed again, I said, let's protect the people. Now, at that point, and I don't know whether it was a wise decision or, again, the exuberance of youth misled me. So far, looking back now, I could say I don't know whether wisdom was still with me, but at that time, I was still convinced, as I am even now, that I was doing everything for the good of the people. I was serving Her Royal Highness, at whose pleasure and under whose orders I served. And I felt like those were clear instructions, and they were genuine instructions in defense and protection of her people, of whom I am a part. So I took out action against ZNS, and actually succeeded in getting an injunction against ZNS. Now, of course, I smile halfway into my statement, because lawyers would be speaking big about, State Proceedings Act, Section 22 and 24. You can't stop the state. Yeah, an injunction cannot lie against the state and all that. But the injunction was not gotten against the state. It was gotten against individual officers. I sued them in the individual capacity, and an injunction came out at ex parte stage. The ex parte order of interim injunction came out. So I wrote in my capacity as vice chair of the Royal Establishment Plans Committee to serve the order of injunction. And I told ZNS at the time, I think it was General Mlenga, who was at the helm of the Zambia National Service. I said within 7 days, your troops should be withdrawn, because part of what the order of interim injunction said, it enjoined them from accessing the land up to 200 meters away. They were to stay 200 meters away from the land and the persons. So,
or from the entire land?
Yes.
The entire 1,500?
Yes, the entire land.
Okay.
And I had said that within 7 days they should, withdraw their troops. If they don't, then we'll, proceed in contempt proceedings against them. So the typical soldier mentality, they ignored it. So after 7 days, I commenced contempt proceedings. But
against who?
Against the
very officers.
Yes,
again.
they called them. It was called in the contract between NAPSA and the ZNS. Was called the project manager. That is the nominated officer from ZNS who oversee the project.
Okay.
Against him, but then I included.
It was a commercial transaction between NAPSA and ZNS.
Yes, as contractor. So but of course, one of the contemners I had included was the ZNS commander, because the officer said, my hands are tied, and I faced off with him, Lieutenant Colonel at the time. First, there was a colonel who unfortunately passed on during that period, and was replaced by a lieutenant colonel, both of whom whose names are not mentioned, because I think they were acting on instructions and in the best interest of the state at the time as enlisted officers, which I think myself in their position, perhaps I could have behaved or reacted the same. So he said, my hands are tied. I cannot, if I withdraw these troops here, I am going to be court-martialed and charged for desertion, leaving the post unattended to. I can't just leave unless I receive instructions from command. And command, they are saying, we can't just wake up and mobilize. The equipment we brought here took days for us to deploy, and so withdrawing also will need admin support in terms of resources. But firstly, in the absence of instruction from high command, I cannot just order the troops here to leave. So that's how I was forced then to include high command. When the contempt proceedings were served on them, the Zambia National Service commander was very angry, because at that time, government had changed. We now had General Solochi as the Zambia National Service commander. Emmanuel, I think, does not like me very well, and I doubt he will also forgive me. So
no, they all have a duty to forgive you. You are dealing with a community matter. It's not personal.
I hope they understand it that way also. So he wrote, around that same time, unfortunately, it must have leaked to him that in fact this kid is Air Force.
Is a Zambia Air Force officer.
So he then wrote to his counterpart. In fact, when that leaked, by the way, General Sorocha had not yet taken over, it was still General Mlenga, who had written to General Muma. You know, and his complaint was there is this issue in the NAPSA land by the source of the Chalimbana River, which is also claimed by the Royal Establishment. And we have been sued, and our troops there are being ordered by one of your people there to leave the area. One of my people, yes, in Twin Palm. So the Air Force commander.
That was highly irregular.
Yeah.
That was highly irregular because you were acting in your capacity as a member of the Royal Establishment.
Nothing to do with
you are not acting as a Zambia Air Force
officer.
Yeah.
You know? So the Air Force commander asked my station commander at Twin Palm to look into the issue. So we've received a complaint from ZNS. Find out, you know, the facts around this issue and let's deal with it. So, you know, Inter went around and I was fished out, and then so I was marched before my station commander for an interview. You know, wanted to establish the capacity in which I was involved in the issue. So I explained. I produced, of course, to my station commander my letter of appointment from Her Royal Highness in that capacity, and I produced part of the court process that I didn't sue NAPSA. NAPSA sued us, and NAPSA didn't sue the Air Force. NAPSA didn't sue me as an officer of the Air Force. I was sued in a private capacity away from service, and this is a private property rights issue. Not that I took out arms to fight the Zambia National Service. So this exclusively is the capacity. But the station commander, because at that time, remember, I had not yet cleared my ZRD. Of course, I had my degree, and I was an enlisted student at the Zambia Institute of Advanced Legal Education, but I had not yet cleared. So his other issue was that I was practicing law on behalf of those poor people, and they were paying me a lot of money in that regard. When
you hadn't obtained the certificate.
I didn't obtain the certificate. So there were going to be two things there. Firstly, I was going to be personating a legal practitioner if those facts were established. Secondly, I was going to be earning extra salary outside of my government pay off of government hours. So I was facing two issues there. But then I clarified that even if I was, of course, a practitioner admitted to the row of practitioners in this country, and I was to issue a bill to those poor peasants, they would take their entire working lives to be able to raise fees to pay, not to pay for a lawyer. I morally, I could not charge them for any fees. Factually, I am not charging them any fees. We are defending in person, and I am doing this on behalf of the Royal Establishment. But then the interview was long, but the long and short was basically this. And at the end of the interview, the station commander said, no, but then if that's the issue, I think we should, there is no problem. The information that the Air Force commander was given is that you were very, you sued ZNS, you kicked them out of there, you sued NAPSA, you want to grab the land from them, and we're wondering because, I mean, there's a public interest there, you're a public officer, so there is a way that you are not supposed to appear like you are sabotaging a government project, you yourself being a public officer. But if the matter is like that and you have grounds to lay claim to your rights, I don't think that we can interfere. That's how that interview ended. Now, shortly afterwards, then of course General Muma said, well, I've been informed that this kid is just there to protect his private rights to land, and it's not acting as an officer of state, is not acting as a lawyer either. It's purely on his, just carrying out his royal functions in that regard. So General Muma left it at that. But shortly, government changed and he was replaced. Well, rather unfairly, I would say, in my period of service, I served 4 presidents and 6 commanders. And as a special ops man, my role primarily was VIP, VI, and VVIP protection. So we protect all the vital installations in this country. we protected all these VIPs. I served many. I served General Mapala, I served General Sakara, I served General Chimese, I served General Muma himself, General Colin Barry, and the current General also, General Nyoni. I served him also because at the time I left, he was deputy to General Barry. I have seen many commanders, and I would say that General Muma was a good general. The reason why he was replaced, those are political issues, but as a professional soldier, is one of the best we have had. On this podium, on any other podium, I've said it every other place I've gone to, that, and me saying that he's a good general is not any reflection on the competencies of the others. I am just talking about him, and it shouldn't be compared with the others. And suffice to say, I served the rest also, and I could say that very confidently about General Muma. And he was of the view that it didn't concern the Air Force. It was a private rights issue. But when government changed, the guys who came in, they took it as their God-ordained mandate to stamp out anything that would have traces of the previous administration. Because every commander who comes in, especially if the commander is replacing another commander on change of government, usually the previous guy did everything wrong, I must do everything right. So mostly everything he did is wrong, and I must, so one of his first executive actions was my case, because I think my file was still, on his desk and the like. And the view he got was that this kid, maybe he wanted to ascribe some political connotation to my status. Maybe he wanted to say that's why General Muma didn't act on this kid. Maybe he's, so General Solochi wrote to him an angry letter, because apparently, and what he said was, this kid, my predecessor had made a complaint, but nothing was done to him, and he went to the area, he beat up officers who were there, and the NAPSA engineers, and that letter that they wrote, come on, look at me, just look at me. I mean, those soldiers are deployed, maybe a platoon of them, 32 of them. How do I go there and start kicking them? I'm kicking these two guys, and the others are standing just waiting for Elijah to kick this guy, then he comes to kick us. Obviously, it's not true. But you see, there was a picture of me that was attached to the letter, a picture of me in combat in the area. I was shocked. I've never been to that land in uniform. But, technology is such a monster that if people will exploit it devoid of morality, they will make beasts out of themselves, and we can hurt each other.
Someone photoshopped
your
picture and put you in the area
to embellish the story, and that incensed the Air Force commander.
The new commander.
Yes, he gave a directive that this chap should be brought and let him be interviewed. For the second time interviewed. Now, maybe because previously my station commander had interviewed me, and according to him, he had written a recommendation to Air Force that there's nothing wrong we found, and the Air Force commander also agreed with him. So this time around, they didn't want me to be interviewed by my station commander, who is my commanding officer anyway. I was told that I would be interviewed from Air Force headquarters, and I would not be interviewed by anyone within that hierarchy of command. I would be interviewed by the provost marshal. So this was a very
formal,
and intimidating setting.
And interrogation, yes.
When I walked in, of course, when I walked in and I was introduced, this is Simbai. You could see his face change. He was visibly angry, and his first words were, "Young man, what's wrong with you? The Air Force commander is very unhappy with you." The ZNS commander wrote a letter. He called the Air Force commander today. I was there. He was complaining very bitterly that you went there to harass soldiers in the area and the like. So what do you want us to do? So I was seated like this, and I say, "Sir, I apologize for the way this information is coming." Then it's pause. So the secretary was told to start taking the minutes of the interview. So I was asked pretty much the same questions that my station commander had previously asked me, and I answered in pretty much the same way. But when in the earlier interview, at the end, my station commander said, well, clearly, legally, nothing wrong with what you're doing, but perception in public service is everything. Even if there is nothing wrong and you are well within your right to carry out the steps that you're carrying out, it still does give a certain perception that may impact negatively on your career. You're a young, promising lawyer, and we are all hoping that you reach the highest limits that the Air Force can, but this might impact negatively on you. I would advise that you consider withdrawing from the matter. Maybe your name should not be there, but you can advise in the background, just so that these who are trying to find cause against you cannot. And I said, sir, I appreciate the guidance, and I will think through that. It's a wise piece of advice. But I had taken no action from the time that I was interviewed the first time to the time that I was interviewed the second time. There wasn't anything new that was done. The record at court was dormant because the matter was in abeyance after the unfortunate demise of His Lordship Justice Chitabomwira, who had conduct of the matter at first. So when he died, we had to wait for reallocation. It stayed long in abeyance. So what General Solochi was reacting from was the hangover from what his predecessor had told him when handing over, that, well, we have this project with NAPSA, but then we have an injunction, only this kid got an injunction against us. And when I interrogated the contract between NAPSA and ZNS, because NAPSA filed it into court as part of their band of documents. So by filing it into court, it was also available to me. There was a clause there on breach which stated that if either part, if works will stall on account of either party, the party at fault will pay the cost. Will pay the other party 10% of the contract sum every month. Now the contract sum was about 453 million, so it means every time every month ZNS must be paying 40-something thousand. I think that was cause for General Solochi to be very angry. That
the project, instead of earning the money, costing the money.
Yeah, it was costing the National Service the money. But then again, I'm a public service worker. I must protect public resources in that regard. But I am also in a position where I must execute my royal duties in the interest of my people. So when the provost marshal now is telling me, in fact, your station commander was asked to sort you out. We don't know why he did not act. Were you not told? I indicated that, of course, respectively, sir, the station commander did advise me, and from the time that he advised me as such, no action has been taken on the matter, because I have actually been seriously considering the advice he had given. So then he says, you should apologize to the station commander, to the Air Force commander, and by extension to the Zambia National Service commander, because they're very angry against you. And I said, perhaps through you, sir, if audience can be secured for me to come before the Air Force commander, so that I can in person express my apologies over the perception that has been created around here, I would be more than happy to take the opportunity. But during that time, there were offers of. There was an offer for me to withdraw from that matter, and then I would be promoted.
Okay.
But then the offer was
informal.
Yes, of course, they will not risk putting that. The offer was based on the fact that purely nothing wrong with what you are doing legally. But like we said, perception is everything. If you withdraw the matter, there will be no direct harm on you. But then you will still maintain your career progression in the Air Force. I had requested for 3 weeks to think about it. After 3 weeks, I had mentioned that I can't, because that offer did not come with any commitment to the people. I had a job in the Air Force. I was accommodated there. I didn't earn much, but I earned enough. And I could get by. But the poor people, and I wasn't
who you were representing.
Who I was representing. I wasn't in this case because I was to get any pecuniary advantage or benefit. None whatsoever. It was pure to protect the people who couldn't protect themselves. But when this offer came, there was no commitment whatsoever to the people. Now, for me, it was a question of I withdraw. Then tomorrow they hear that he's now a big guy and he exists as a car. They will look at me obviously as a traitor, and for me that is a far worse tag to stay on my conscience, far worse than poverty. I would rather remain the way I was, but not betray the people. But now, from the Provost Marshal's interview, the language changed. It was no longer withdraw, then we'll promote you. It was you choose between your job and and these people. The tone of the Provost Marshal gave me an indication of what they were up to. So after that extremely intimidating and humiliating interview, I went home and wrote to retire because I had served at that time 12 years. I was due to go on early retirement, so I wrote to retire. I served my retirement letter on my commander, my station commander at Twin Palm. Of course, then it was escalated. But I was told that your retirement has been rejected by command. And then 2 weeks later, my letter of dismissal I was served the letter of dismissal.
They refused you to retire, and then proceeded to dismiss you.
To dismiss me. Now, my letter of dismissal is actually here. And sorry to bedevil you with a bunch of this document. It's actually here. It says in brief that you have been discharged from the regular Air Force effective it was given to me on the 10th. Effective the 2nd of February 2022, on the grounds that your services are no longer required, pursuant to Section 21 of the Defense Act, Chapter 106 of the Laws of Zambia. Then they go on to say you shall be given your pension benefit as calculated pursuant to Section 36 of the Public Service Pensions Act. So I read it, written by Lieutenant Colonel Jane Nyirenda. So I read the letter.
What was your rank at the time?
I was a flight sergeant. So I read the letter. Of course, I had been in the legal department, and at my master's, by the way, my master's was in constitutional and administrative law. The Air Force took me through, constitutional and administrative law training at master's
program.
Yes, and my research was on administrative justice within the Defense Force, a case study of the Zambia Air Force. So I thoroughly was academically required to study and interrogate the Defense Act. So I know the Defense Act a lot more than very few in the Air Force do. Perhaps I could.
Studied it at
yes, I studied it. It was an academic burden for me. And I knew the implication of a Lieutenant Colonel writing to dismiss me, and based on the section that was quoted, because
who should have written to you?
It was supposed to be the Air Commander, Section 21. It is the Air Commander, the Air Force Commander can at any time discharge a regular soldier from the Defense Force on the conditions set out in the second schedule, Part 18 of the second schedule. The second schedule lists the grounds on which a person can be dismissed. It lists also the appropriate authority that can undertake that action. It's the Air Commander. So it was now Lieutenant Colonel who wrote it to me.
We have to, before we lose our audience in these technicalities, what is the state of the case of NAPSA, ZNS versus the people in that village at...
The ZNS case was exhausted because at inter partes, the judge discharged our ex parte order and guided that since ZNS is claiming that they are acting as an agent of NAPSA, whatever you are claiming against them for the assault on the people and all that, claim against NAPSA as an agent of NAPSA. So then the matter was consolidated. Our case with ZNS, they said this matter can be consolidated with a NAPSA matter because ZNS are saying they acted as agents.
Or
so then you can demand.
The earlier legal matter by NAPSA to sue you.
Yes.
So it's now consolidated with your other action.
With their claims against ZNS. So they said, okay, we should claim them against NAPSA because NAPSA is the principal, ZNS were just agents. Agents.
Where are we with that matter?
That matter, of course, right now is at settlement stage because after some time, the new NAPSA management apparently agreed with my earlier proposal for settlement. And graciously, the Director General of NAPSA reached out and he demonstrated willingness to resolve this issue. His rationale is that, 4 years with this matter, it has...
it's lost some money.
Yeah, they're losing money and so they reached out for settlement and that's the stage.
So there's an opportunity to settle the matter.
Yes, it has actually reached, the settlement has actually escalated. It's no longer even in my hands. I think now the state is going to handle it with NAPSA, together with the rail establishment at that level. Yeah, because a number of things have happened. Greed crept in. Some of my own people in the rail establishment, the picture I think at some point they started getting was that I was going to make a lot of money, out of this NAPSA settlement.
Oh, when it comes, when you do this community work, when it comes to settlement, it means money. It means maybe NAPSA may compensate. It means NAPSA may give land. It may grow out of your hand because now they are commercial interest after you fought for the last 4 or 5 years. So I understand it's good, but in the end, our people should not lose. If they are being compensated, let it be proper, adequate compensation. And let the right people get the compensation. Then with your troubles with ZAF, now you have this constructive dismissal. Have you challenged it?
Yes, I actually challenged it in the High Court. I saw the judicial review. There was a time when the government was saying those who were unfairly dismissed, we can consider them, My name at some point was floated, by the rail establishment. But I know many of my colleagues who had been dismissed, whether under the previous administration or this administration, and they had requested that administratively perhaps their cases should be looked into so that they are recorded. I know men who have been recorded. I was not recorded. And I realized that Air Force Command might have said, if you recall this kid, the matter... subject of the basis of what led to his dismissal is still active. And there are other implications that may impact very negatively on some of them. Some of them were involved in quite scandalous ways along the way.
This brings me to the reason you are on this podcast, is that a friend of mine, a journalist and public commentator, Dixon Jerry, wrote about your matter, where there were allegations by the Air Force that you were not a qualified lawyer, that you do not have a degree to become a lawyer. And it was a subject of litigation, and Dixon Jerry wrote about it. Just tell us about that matter and about the position from your side.
Yeah, well, thank you very much for that question, Ambassador. I'm not on Facebook. I haven't been, I think, for quite a while.
Why not? Why not?
I don't know.
Let's see a parent say that, not you young people. You are supposed to be on Twitter, you are supposed to be on Facebook, you are supposed to be on Instagram, you are supposed to be everywhere. But I understand.
Yes,
there are many young people that actually find social media in general very oppressive.
Yeah, it actually is.
It also causes harm. There's a lot of things around social media. So it's not as glamorous as I'm trying to put it. There are concerns, So I respect your decision.
Thank you very much, sir. So someone just, to start with, the day before yesterday, I woke up to tons of messages on my WhatsApp and a lot of missed calls. friends who were former Ziare classmates, former classmates at the Zambia Open University at degree level, people who generally know me, people from church. Some of them actually very worried because my phone was on silent. Of course, I was sleeping, the phone is on silent, so I didn't see most of the... Some of them so worried that they thought maybe I was so depressed, I'd even killed myself and the like. So I asked why the agitation? They said, well, we've seen the post on Facebook on Mr. Dixon Jerry's page. So I said, well, I haven't seen it. I'm not on Facebook myself. What is he saying? No, he has written something about you forging, not having a degree and you losing the case in the Constitutional Court. Now, then, well, okay, I don't know what he's saying. Probably if you can send to me, screenshot and send to me what he's saying. So I read, when I read the statement, it was quite misinformation to a great extent. I didn't quite understand the motive, but I'm a very reasonable person, and I thought it's unfair to just condemn or dismiss a person unheard. So I requested for his number. I called him. When I called him, he picked up, and then I introduced myself. No, Mr. Jerry, my name is Elijah Simbai. I'm the gentleman. I said, my name is Elijah Simbai. He said, okay, yes, sir. And I said, I'm the gentleman who had a matter in the Constitutional Court to do with Ziale, about whom you wrote. I'm told you. Then he said, okay, right now I'm in a meeting, I'll call you back. He hasn't called since. I tried to call him twice or thrice later, he didn't pick up. So one of my friends, former colleague in the Air Force also, is no longer serving also, who had also seen the post and he had texted me. So I engaged him. I said, I don't know what the reason for that post really is, but I've tried to engage Senior Counsel Jerry. He's not very responsive, but I want to get, especially the motive, you know.
What did you take to the Constitutional Court, and what did the Constitutional Court rule?
For the sake of sort of context, there were actually two matters, and that's why I wondered as to the motive why this was published. There were two matters we took to the Constitutional Court. The first one was about concerning our retirement, you know, our separation from the Air Force, myself and 11 others. But that matter had a number of other things that we had raised. For example, before General Barry's administration, they had written some circular which they had distributed to all formations, saying that you should not implement SI number 12 of 2023 because it's illegal, it's unconstitutional. This is
a statutory instrument by the president.
Yes.
Extending the benefits of retirement from 55 to 60 and 65 to the defense forces. I saw that SI and I published it. And when I published it, I cautioned that I don't think the president must extend this to the defense forces, because you in the defense forces have your own conditions. One, for example, that you have to have young people. So you can't have an old army. You cannot. Two, age is very important, even both for commanders and the regulars officers. So for me, I commented from that perspective. So I remember that SI very well. And I thought that there was wisdom earlier where we had extended retirement age for public service workers from 55 to 60 to 65. I personally didn't agree with it. I differed with Roland Musiska, who was Secretary to Cabinet at the time. I said, this is a young country. You old people are already occupying all these positions, and now you are extending yourselves up to 65. When will young people be employed? No. Look at Japan. Japan has extended retirement age to 70, in fact, 70, 75, sometimes even to 80, because most of the experience is gotten when people are usually in the afternoon of their lives. At 50, that's the time many even obtain a doctorate or a master's, or then the experience, so you need to extend. I said, no, this is a young country. Look at the population. But for you, the people in the defense forces are trouble. Because then I saw an old army. That's all I saw. So I said, but why hasn't the president taken wisdom from the people that crafted this extension? Because they excluded the defense forces. So in your petition, you had raised this to the Constitutional Court.
We had raised the issue before
what were your arguments?
The Constitutional Court. And before I remember I talk about the arguments, just very interesting to comment on what you have said, although you must have mentioned it in passing. And I must also maybe digress a bit by saying, I am lately I've been a very keen follower of this podcast for a good reason. There are many podcasts, of course, many podcasts around in Zambia. But where national matters are concerned, I am enthralled by your depth and diversity of knowledge in public administration in particular. I thought you were a lawyer, so I don't know what your expertise is, because there are even the questions that you'd put forward when you are interviewing lawyers here. They are very legally grounded. The comment you made that members of the defense force have their own separate conditions of service. Unfortunately, very few people know that. Even members of the defense force themselves, up to now, members of the defense force in the Zambia Army and Zambia Air Force have been retired based on the Public Service Pensions Act and rules. When we have, let me just demonstrate something.
Yeah. No, you are allowed freedom to.
Documents. I was going to refer to SI number 61, of course, of 2014, which amended the public service pensions rules. And it states clearly, President, the last person to amend the PSPF before President HH, of course, was President Michael Sata. And at that time, of course, the acting president was President Guy Scott, who had signed that SI into law. It states that these regulations, that is the public service pensions regulations, shall not apply to members of the defense force. And we are not supposed to be retired. Members of the defense force are not supposed to be retired pursuant to the public service pension rules and regulations. And the reason is very simple. Because the Defense Act itself has got defense pensions, Defense Regular Force Pensions Regulations within the Defense Act. Very peculiar conditions of service to members of the Defense Force. One such peculiar condition of service is the fact that members of the Defense Force, and I'm talking about Regulation 19 of the Defense Force Regulations, pensions regulations, members of the Defense Force can retire upon attaining 10 years of service. They can go on early retirement. Now, that does not apply to other public service pension workers. Now, if you're going to talk about experience, what experience are you going to talk about in killing or dying in war? Because the efficiency of the military life is closely tied to youth, energy, and exuberance. So the younger, the better. When you reach ages of 60, you cannot run in war. You cannot better command war. Militaries around the world, very effective militaries around the world, they are very young and vibrant. But if you are going to say, well, members of the judiciary, for example, they are allowed to retire at 70. That's judges. What do? They sit in a chair and they read. You don't sit in a chair as commander. You have to run around in war. So it's quite a different. With a judge, of course, wisdom grows with age, but energy reduces with age. And for us who are fighters, the younger, the better. And like you have said, we have different conditions of service. But SI number 12 of 2023 was a bit problematic because it said that the retirement was tied to ranks and age. So, for example, it said that A person who holds the rank of Lieutenant Colonel and below may retire when they reach the age of 57 years. Now, but Colonel and above, you retire at 60 and you could extend to, they say you could extend to 65, something like that. Now, a person, depending on when they were enlisted into the Air Force, they could become colonels after, I know some colonels of probably who became colonel upon 17 years of service. Now, if you were enlisted at the age of 18, immediately leave high school. 17 years later would maybe 35 years. So at 35, you are colonel. But even if you want to live and pursue other things, it means you must serve 30 more years. Because now, once you become colonel, you are locked in. If you leave, you just resign. You just walk away like you went to a shopping mall. So
when I wrote that, it generated interest. Some even told me to keep away from issues of defense. But I said I'm a defense and security expert too, from the academic perspective, because I've studied about peace and security studies. So I take interest in these matters. But I heard that there was a secretary to cabinet memo that was written to the defense forces to say that literally at best that they should ignore the SI signed by the president.
And that's what we had issue with, because
to your knowledge, since you were pursuing this matter, did you come across that information?
Yes.
Did you come across that document?
Yes, we did, and we did not know that there was such a document. What we knew was we saw the circular.
Yeah.
And we were wondering...
The circular signed by the president.
Yes.
By the
no, not by the president, but by...
Secretary to cabinet.
No. By Air Force Command. To Air Force formations.
You.
Yes, to Air
because
Force formations.
Because they had to convey what Secretary to cabinet had written, that the president had signed this SI.
Don't implement this. So we were saying...
Just repeat that. So... amongst your formation, there was a memo to you.
Yes.
That the SI will not apply to you people in the Zambia Air Force.
In the Zambia Air Force. They said, don't implement this because, and the reasons that were cited were that because it's illegal and it's unconstitutional. Wow. And to me, it sounded very strange that an officer, an enlisted officer could say of...
a presidential document
directive signed by the president
and unconstitutional.
Commander-in-Chief of the Armed Forces that disregard it, it's illegal, don't follow it. Yeah. Now, that was the one issue.
So that write-up was based on a communication by the Secretary to Cabinet to the Defense Forces that they should ignore. I think because I think then they were going to find time to persuade the president, I think, on the reasons why that SI was irregular.
Yes, apparently.
But so in your case, it was conveyed to you that it will not be, it will not apply.
Don't apply it. Now, there was double standards there. Our natural instinct was, they are saying don't implement this because it injures them, the big guys up there. Meanwhile, the guys below here, when they want to retire, they make sure that they clip all the favorable conditions for them so they can go with as little money as possible. Meanwhile, an SI that potentially also makes them live with as little money as possible. If they live before those ages, they are saying don't implement it. So as we just looked at it as, the usual greed and the oppressive system of... So when we raised those issues, and our issue was whether a person other than the Constitutional Court has got the powers at law to declare a law unconstitutional or illegal. Because, we
so in your view, the ZAF commander had no powers to declare that the SI by the president was illegal and unconstitutional.
He had no powers. But beyond that, we felt that was actually a bit unusual. The president is commander-in-chief of the armed forces, and the submission and loyalty of all enlisted and commissioned personnel in the defense forces to the president is unqualified. That loyalty is unqualified. You can't say, yes, sir, I will do it, but it sounds a bit idiotic. You can't. It's unqualified, whether it's idiotic or it's... As a soldier, we are bound by whatever instructions come from there. At best, we may advise, but we have no power to override, no power to say that, well, you can't apply. That was the basis.
So did you take that to court?
We took it to court, and when we took it to court, then ZAF responded. But unfortunately, if you are raising constitutional issues, you always have to cite the Attorney General. So the Attorney General is our respondent. Of course, there were a few other things that we raised. So when the Attorney General, of course, referred it to the Air Force Legal Department, then they responded. So in their response, they said, well, yeah, we say that it's unconstitutional, but these people, in very demeaning language, very demeaning language. No, these slightly short of saying these chaps are speaking from a point of ignorance, they don't know really how government operates and the like. So they said, well, Command acted the way it acted because, in fact, there was a write-up from the Attorney General, from Ministry of Defense and the Attorney General's chambers, So because they were putting those in the affidavits, then they put those letters as exhibits. And we have copies of those letters here.
So they brought to court letters instructing the ZAF commander not to implement the SI from the president.
Yes. However, to be fair, maybe to the documents I came across were the ones, the letters we came across that were, of course, brought before court as exhibits, were the ones written by the PS Defense and, of course, the Solicitor General. To be fair to them...
So if they were filed in court, they're public documents?
They're public documents, anyone
so
can
you have
conduct
them and they can have them?
Yes, I mean... Mr. Dixon J already put up the cause number for that case. You can just search it, go there, conduct a search. I think it's about 8 kwacha or something. They'll give you these documents. They are public documents. Of course,
read one of the letters.
Some may say, okay, I'll read a portion of...
Yeah. Just to demonstrate that the ZAF commander instructed you not to disregard the SI by the president, and also any relation, any correspondence that was filed in court to say the same thing.
So there's this, of course, that was written by the PS.
Just speak through the microphone.
Sorry. There is this that was written by the PS.
It's a letter dated?
Dated the 9th of August, 2023.
Written to?
In fact, it's dated 4th August, 2023, but the date stamp is for the 9th, for whatever reason. Maybe this is the time that it was received by, I think this is Zambia Airforelce stamp. Written to... Oh, in fact, no, this one is from the Solicitor General written to the PS. So okay. The SG wrote to the PS. We
start from the Attorney General chambers. They're advising the PS.
The PS.
What are they saying? Yes,
so it's some long 12-page document, but at the end here it says, conclusion. In consequence of the be above, the PSPF may not be able to comply with Article 1.
PSPF, what's PF?
Public Service Pension Fund.
Okay.
May not be able to comply with Article 189. Now, may not be able to comply with Article 189 because, remember, Article 189 mandates all employers to pay retirees their pension benefits on retirement, on the date of leaving work. And if on the date of leaving work they're not able to pay them their benefits, then they must maintain them on the payroll until such a time when... So they're saying, if that is the case, PSPF may not be able to comply. We may have an influx of people leaving, and we may not pay them their benefits at that time, and we may be forced to maintain them on the payroll. We are going to have such a salary burden that will be very overburdening on the Treasury. So may not be able to comply with Article 189 of the Constitution, and this will expose government to lawsuits in the Constitutional Court, which will be difficult or impossible to defend. The Minister of Defense should immediately issue a directive to all the services to stop implementing this SI.
The SI, what is the SI number again?
12 of 2023.
Issued by the President.
Issued by the President.
Yeah. So the Attorney General chambers advise the PS Defense to ignore the directive of the President.
Yes.
Yeah.
Then PS himself also writes
now to the Defense Forces.
To the Defense Forces now.
And these documents were were produced in court.
Yes, it was who produced these documents. It was the Attorney General themselves who produced these documents. So then the PS himself writes, the last paragraph here says, I therefore issue a directive to all the services to stop implementing the SI. So, and the reason here, because it's unconstitutional, it's illegal and unconstitutional, blah, 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 those issues.
Yeah.
But now our quarrel with that was that article, for example, 191, or is it 91 rather? I think article 165, 166 or so, which gives persons power to enact delegated legislation, such as SIs. The Constitution says that the powers in this Constitution to enact or sign into law any piece of legislation include the power to amend, revoke, or repeal such as legislation. So if you, Ambassador, are given the power that you can promulgate regulations of how the Patriotic Front Party can run. So until you sign those regulations, they are not enforced, because only you who's given the powers to promulgate those, to enact and promulgate by law. But then the fact that the Constitution says that power includes also the power of revocation, amendment, and repeal. It means once you've promulgated those regulations, however defective, however irregular, they are the law to live by. Until you
in your view, the SI was valid?
It was law until the president again revoked it. Now, you don't revoke a law by just sitting and say, that law, I revoke it.
Or by letters by the Attorney General's Chairperson.
No. Even the president himself, he can't just stand and say, I have revoked it, because now the Interpretations Act of Chapter 2 of the Laws of Zambia guides on how a law is repealed. A law is only repealed by another law. So you must enact a law repealing the previous law. So the president then should have signed another SI, amending that SI, or revoking it and replacing it with the one now which might comply according to the advice and concerns. But that wasn't done. So that's why we went to the Constitutional Court. So that
what did the Constitutional Court say on this particular matter? Have you gotten the judgment?
We have. It never even saw the day of light, because it was dismissed on ruling. The Constitutional Court says we have no powers to pronounce ourselves on we have no jurisdiction, was their classic statement. They have no jurisdiction.
Or they refused to hear the matter.
They refused. They heard the matter, but they refused to determine the matter.
On jurisdiction?
Yes, they said they don't have jurisdiction. So the Constitutional Court has got no jurisdiction to determine the constitutionality of an act, of the actions of a public servant. Interesting, very interesting.
No, I'll need to read that.
But that's what, yeah,
spark debate amongst lawyers.
I have a copy of the ruling here.
Yeah, you should give me. And I'm interested in those letters that literally, by practice, revoke the SI of the president.
Yeah,
that's highly irregular, and I'm glad that the authorities produced them in court, so they become public documents.
Yes.
And we can. The other matter questioning, Elijah, the other matter questioning your qualifications.
So now, I'm the one who sued. Remember, in this one we sued, and the other one also we sued. We filed these two into court at the same time, and they were heard on the same day, the same panel of judges. And I think that was my undoing. I think that the moment that these two matters were heard by the same judges, my fate was sealed. Because then it appears like, oh, so it's this kid on both issues. So it's very different that we can consider this one way and then we'll consider the other way. Now, the reason for the second case was, remember, the Air Force fired me on the condition that my services are no longer required. That's the reason they gave.
In the letter.
In the letter. All the interviews they gave me were based on that land transaction, my involvement, how I sued the state and all that. So they fired me. When I sued in August of 2022, in their defense, because I'm suing for judicial review, I'm saying the decision was firstly in excess of jurisdiction, and that's because Lieutenant Colonel cannot fire me. You know. Secondly, it was procedurally proper because I was not put through the due process of the law. I should have been tried. There should have been a particular offense
cited
against me. I should have been tried through court-martial, and I should have presented my evidence, then convicted, and if I'm found wanting, then I should have been kicked out. But a letter just came, and that letter came in response to my application to retire. Thirdly, I was saying it was unreasonable. The punishment was excessive because I could have been demoted, reduced to the rank. I could have been suspended, but
besides,
but
you did nothing wrong. You did nothing wrong.
Yes,
you did nothing wrong. Unless you are doing these things during man hours of the Air Force.
Yeah.
But this was a private matter you were pursuing.
Yeah. So I challenged on those three grounds. But on the issue of procedural impropriety, or in excess of jurisdiction, where I said this Lieutenant Colonel cannot fire me, the law says the Air Force commander should. Then in court, they produced some letter written a few days before the date of Lieutenant Colonel Nyirenda's letter, purportedly written and signed by General Chipasha on behalf of the Air Force commander. So they're saying, no, this is how he was fired on the basis of this letter. And I was saying, but if then this letter was written by the Air Force commander to fire me,
why wasn't it given
why
to
wasn't
you?
it served on me, firstly? And why did this gentleman also need to write another letter also fire? It's an overkill. How do you fire some guy twice?
2 letters.
The MD fires, then again the supervisor fires. It doesn't happen that way, you know. If the firing was by the Air Force commander, I should have been served the letter. At best, if you wanted to notify my immediate commander there, you could have fired me, written the letter to me, and then copied him. Then you would have had the records. So this is clearly an afterthought. There is no way you can have 2 letters to dismiss some guy. So that's how they tried to work around that, the issue of excess of jurisdiction. Procedural impropriety, they said, well, he wasn't charged with any offense, but this gentleman was interviewed. And in the interviews, he admitted that he had done some wrongdoing. In fact, he admitted to forging Ziale results.
The transcripts. The transcript is what Dixon cited.
Yes, cited.
Speak to that.
Now, I have all the 2 interviews, the ones by my station commander, and there was secretary there.
Officer.
Nothing is mentioned there about Ziale. The issue under discussion was an NAPSA land, how you got involved. I mean, it's in court. It's also a public document. We can publish them even on Facebook. It is them who are interviewing me. It's their people who are writing the minutes. Not me that they should know that chap changed edited the minutes. It was their own officers who were secretaries. Nothing there was mentioned about Ziale results, forging, and the issue was about the land, how I was involved. So this is an afterthought. Now they are saying he forged Ziale results in 2019. Now this is definitely true. Forged Ziale results in 2019. So I'm like, 2019 I forged Ziale results. Why is it only being reported in 2022, 2 weeks after I served them with my judicial review proceedings? That's when they wrote the letter of complaint to Ziale. So
what is the standing of your qualifications? Walk us through again.
Well, I have here my degree from the Zambia Open University. I have my certification from the Zambia Qualifications Authority, because when we enrolled into Ziale, they had put it as a mandatory condition then that all those who were to enlist are to have their results certified. At first, they had said, those of you who are enrolling on account of your transcript of results from your various universities, you must have ZACA to certify those results. And without the ZACA certificate, will not accept your...
So Zambia Qualification Authority certified your transcript?
Yes, I have the certificate here of my certification. So they certified my transcript of results, and that's how I was into
your
Ziale.
Ziale program, did you pass?
Yes, I did. I cleared my Ziale in 2021, but before I could, it means I was supposed to be called early 2022 to the bar. So I applied to petition the Chief Justice for my license. Then Ziale wrote to me, says, you've been removed on the list of practitioners to be called to the bar because you didn't produce a degree certificate. So I write back that firstly, you put a condition that those of us who didn't have degree certificates Because we enrolled into Ziali before graduation came. You know, some universities, graduation is a year after you complete your coursework. Those of us who had enrolled on account of transcript results, you had asked us to produce Zaka certification, and my results were duly certified. I have the certificate here. And beyond that, in fact, after those of us who had enrolled on,
me the certificate.
On transcript of results,
because they have not called you to the bar, and it appears that there has been interference by your employer or former employer, and their allegations are beginning to hold water against you.
especially that...
now that it has even affected the ruling.
Another big...
I can see you have documents. Just bring the documents for...
This one. Okay, this is my Zaka, a copy of my Zambia Qualification Authority.
Okay, so the Qualification Authority certificate of validation of qualification order, Simbai Elijah, NRC number, and there is a Zaka reference number. And the date of validation of your evaluation is 8th January 2018. Recognized Zambian qualification, bachelor's degree. The transcript leading to the Bachelor's of Law has been validated as genuinely awarded to Simbai Elijah on 29th June 2017 by the Zambia Open University, a registered and recognized institution of higher education authority under the Ministry of Higher Education in Zambia. The qualification is recognized in Zambia as a bachelor's degree at level 7 of the Zambia Qualification Authority, issued by the Zambia Qualification Authority, signed by Mrs. M.A. Chiava, Director and Chief Executive Officer. And this you produced in court.
I produced, that in fact is a court file. That's a court file. That was exhibited as part of my evidence in court. And the very next page is a copy of my degree. It was also exhibited in court. It was also exhibited in court. Those are actually my they said, is it transcript? I think,
transcript,
or perhaps some email from, so all my qualifications are in there. And they were presented in evidence.
Where does this issue that questions your qualification come from?
It comes from a point of desperate bitterness by a few high flyers in the Air Force who feel that they have a personal vendetta to settle against me. Firstly, they felt grossly infuriated by the fact that I dared challenge their decision to fire me like that, and the court granted the order for judicial review.
So do you suspect that they reported to, for example, the Chief Justice that you should not be admitted to the bar?
No, it's not a suspicion. There are letters there. The first letter was written by Colonel Mwamba. Colonel Mwamba is the current Chief of Administration in the Zambia Air Force. He wrote to complain that, he's the one who wrote first that Elijah Simbai forged his, his results in 2019. And look, the letter says I forged those qualifications in 2019. But they are only writing in 2022 to Ziale, only after I sued them in judicial review, a week after I served them with judicial review process.
What is the basis of their allegation that you forged the results when the documents demonstrate that you have valid...
Yeah, and that's that's why I say, look, the system can be very, very malicious. And unfortunately, I always say that there is always a human cost to justice and there is a human face to government. People just like hiding behind these institutions, but there are actual people, individual, angry, mean, cruel, jealous people behind these institutions who are... ZAF is not a beast you find around that is grazing, we can shoot it, or it's people behind these institutions. People behind these institutions, they write letters.
How are you normalizing this? we want to see you graduate. We want to see a brilliant mind like yours practice law. I
have hit a dead end now because, I mean, the Constitutional Court is the highest court of arbiter. Is the highest arbiter, rather, in this jurisdiction on constitutional matters. A person who is aggrieved where they feel their constitutional entitlements or rights are being or have been infringed goes to the Constitutional Court. I went to the Constitutional Court. But before I went to the Constitutional Court, I went everywhere else that I could have gone. Now, I have people whom, some people were calling me, they were saying, but why did you go to the Constitutional Court? You've sealed your fate. Why didn't you just engage your former employers privately and resolve these issues? I have engaged with them. I have a letter here that I wrote to the president of LAS requesting for audience with him in 2023, before I even went to the Constitutional Court. I was denied audience. I have approached Ziale several times. There's a back and forth number of letters that I wrote requesting for audience, requesting even to be heard. I'd even asked them to say, by your own rules, the Ziale student rules, section 29 and 30 of the 2021 promulgated Ziale rules, they are not supposed to condemn a student. Before hearing them, I was never heard. Then they're just saying,
so Ziale got a report from
ZAF.
From ZAF.
Yes.
That you forged your transcript from Zambia Open University.
Yes.
And Ziale, although you passed their exams, decided to not to give you the certificate.
Yes, they decided they're not going to approve, to have me recommended to the Chief Justice that I'm called to the bar. I've seen everyone that could have been seen. My last resort was the Constitutional Court. The Constitutional Court dismissed me. They said, well, we can't. There's no constitutional issue here. If Ziale, what they are saying is, well, there is no time frame within which Ziale is to take action. Now, it has taken 2 years, but the Constitutional Court is saying that delay is not unconstitutional. We can't compel them to act on your case because there is no constitutional breach.
No, I took interest in your matter because all I see is malice. All I see it doesn't take long between Zambia Qualification Authority, Zambia Open University, and Ziale to verify whatever concerns they have. Yeah. And they should not collude with your employer who you are fighting in court. And in your case, you even have a bigger burden than NAPSA case, sitting on a high-value land where you are fighting this giant and you're trying to get justice for, those 89 households. If you hadn't taken that matter, you'll be living at peace with Zambia Airforelce. You'll be an accredited lawyer. You will not have all the problems you have. The problems you have are simply because you stood up against this giant in NAPSA. You took, these decisions against these very big people. And for me, I think you needed to be heard. I wish that we had more people like you in our country, because we suffer condemnation so that the crime that people perpetrate can continue. We suffer isolation and scandalization so that the crime they are doing, the scandal they are doing, is not unearthed. So as we come to the end of the program, I hope that the issue of you being admitted to the bar will be accepted. And I'm encouraging you to give us a copy of the ruling from the Constitutional Court. I think maybe my dear brother Dixon Jerry could have done not a comprehensive approach in the manner that we've done with it. Maybe there could be other angles. We journalists say to the same speech, there can be 10 stories from the same speech. So from your Constitutional Court ruling, there could be other stories that can help make us understand your matter. And for me, again, like I said, there was a matter I was probing of extension of retirement age that was extended by the president to the defense forces, and which you took up. You took up with force, and it even reveals the rot. The Attorney General cannot appeal the SI of the president. The Secretary of Cabinet cannot appeal the SI of the president. The permanent secretary, Ministry of Defense, cannot repeal the decision of the president. In this case, only the president can revoke his own SI if it is unsound, if it's unconstitutional, if it is illegal. So there are many things that we've learned in this podcast. So I'll ask you, Elijah, to say your last words.
My last words would be, I'm tired. Sorry. I'm tired. I don't know. The only thing I would have... The only thing I would have wanted, perhaps that I sought to engage Mr. Dixon Jere on, was to find out exactly what the motive was, so that if he made the statement he made from a point of misinformation, maybe I could avail certain pieces of information that may set the picture right. But if the motive was just to create a narrative that I am a mischievous fellow, I'll say it's quite unfortunate that for a senior lawyer like him, who has a better chance and stands from a better position to find himself in defense of the weak and the marginalized, can actually take steps that embolden and entrenches more the powers of the oppressor. It would be very, very unfortunate. And I hope that maybe one day he will watch this podcast and get to see how he has, what that write-up has impacted me. For me, I would say it's done. I'm at the mercy of Ziale now, whether they take 10 years or 100 years or 2 years more to look at my issue. The Constitutional Court has given them a long leash, has put them on a long leash. So I'm at their mercy, really. And whether or not they exonerate me at the end of it all and give me my license, it's really up to them. But you see, whether I'm given my license today or I'm given my license tomorrow, the 2 years I have lost, 2 years of practice I've lost, never be recovered. And also the injury on my reputation is quite substantial. If I'm never given my license or I never practiced law in this country, I've made peace with that. And I find comfort in the fact that I sacrificed it all in defense of the poor. For me, I would die with a conscience slightly clearer. But I wished things turned out differently, but I'm tired of all this, the running around, the hide and seek with few individuals in the Air Force. It's very unfortunate.
Thank you very much. Elijah Simbai was my guest. I hope you learned a lot of things, and I grieve with Elijah Simbai and the circumstances he had to go through just to defend those poor people whose land, whose parents have buried on, whose forefathers have buried on, and are trying to be evicted. He has paid a high price where he has lost his job at the Zambia Airforce, a young, ambitious career, very brilliant, as you saw in his expression, clear, thought-minded, someone who understands his work, and who is passionately committed at no pay, no benefit, just to empower, first Her Royal Highness, Chieftainess Nkomesha, Dr. Chieftainess Nkomesha, and the people that suffer displacement because of this modern development that we undertake. Elijah sacrificed his life for the poor people, and he has run to courts where he has had no joy. He has run to institutions and to authorities, and they all appear to conspire just to put him away, you know. So with that, I would like, we pray for a better Zambia. We are Zambia at 60. Our country should be better. We should put the rot that we've been experiencing in the last 30 years behind us. Until we have another special guest, pray for Elijah Simbai for strength so that he sees through this. I want to see him trotting at the Lusaka Magistrate Court. I want to see him trot at the High Court. I want to see him trot at the Supreme Court. I want to see him trot at the Constitutional Court, defending the poor and practicing what he loves, which is the law. God bless you. God bless our country. Until next time, shalom, shalom.